Now, Amit, there is a question to you by Ketan Kamath. Amit Mehtaji, our society has a conveyance deed, but PR card, Malmatta Patrak does not bear the society's name. It is still in the builder's name? Do the society need to get this name on the property card first and then go for the redevelopment, or what is your guideline on this?
Yeah, if the same builder is continuing the project, then you don't need to do it at this point of time. Otherwise, it is advisable to first put your name and then continue for development.
Okay, Seema Seth has a question. What about litigations on the prospective developers? Is it safe to give a redevelopment to such developer whose balance sheet is around 25 crore and who says will join the hands with the XYZ developer? That means they have got various litigations. The developers are having, various litigation background, and they are saying that we will involve another developer and we will complete your redevelopment. Is it advisable to give the redevelopment to such developer?
I don't want to know the name of the developer, but of course, in such situation, I would prefer the answer is no. It is better to have a clear-cut developer who has funds available with him, unless until he has a track record where he has already completed so many projects without litigation and had earlier funds, but now he doesn't have funds. Then I can still consider. Otherwise, the answer is no.
Okay. We want to arrange a self-redevelopment seminar in our society. Please advise. Yes, anybody who wants to arrange a program in their societies and or in a local area, MahaSeWA with Rotary Club and other associates like Amit Mehta, Sandeep Kangutkar, we will be very happy to be a part of such programs. There can be, if it is a one society redevelopment, there may be certain professional fees involved. Otherwise, if it's a public program, it can be done on free of cost. So the next is there any other? Yes. 3311 does not, passing authority does not go to BMC or SR authority as being society registered in BMC. Does the society come in MADA or SRA? Rachna has a question. Amit, if you can answer, otherwise I will answer.
Yeah, I can throw only one light on this.
Yeah, 3311.
Yeah, 3311 it is called PTC. That can be, it's a new trend right now because it gives some extra FSI to societies. So if the society is willing to go for this particular scheme, then it is advisable to take this scheme. You may get a little extra benefit in that.
Okay. There is another question from by Atul. Sir, please highlight the difference between MOFA and RERA. FSI calculation in suburb area. So, Mehtaji, can you highlight what are the difference between MOFA and RERA? Legal provisions.
See, the MOFA and RERA has nothing to do with the FSI. FSI is purely related to the plot of the property. But MOFA and RERA, obviously, you would know that MOFA was earlier there till 2016. And after that, it got abolished, and then RERA continues from 2016 onwards. And we all know the benefits of RERA over MOFA. The good part about RERA is the civil courts are now sidelined as far as the RERA is concerned. You don't need to go to the city civil court. Now, if they are directly go to the RERA appellate court and directly to the high court. Earlier, the city civil court used to take a lot of time. You still have the option of going to the consumer court. But the good part about RERA is another advantage is there. It is time bound. So what happens once the case is filed in RERA, it is time bound, it is disposed of in a time bound way. And though I was a part of the RERA drafting committee and it was a highly neutral type of the bill which was introduced by the government of India. But I am still of the personal opinion, it is highly still pro-consumer and which is the advantage to all of us.
Okay. So I can just tell you that Maharashtra Ownership Right Act was the act enacted in the year 1963 prior to enactment of RERA. And this is morely related to Maharashtra, whereas RERA is a Real Estate Regulation and Development Act across India. Now, in the MOFA, certain provisions or the compliance was required to be done by the developer. Obligations were cast on the developer. And if he does not comply, we could go to the city civil court, consumer court, or in the magistrate court and book the developer. Whereas in the case of RERA, you don't have to run pillar to post. Even before the sale of the flat, the builder has to get the clear title, commencement certificate, and all the approval in place. Thereafter, the RERA project gets registered. Thereafter, only he can sell the flats. And there is a lot of transparency which is available in RERA. And as far as litigation is concerned, now you will be able to go only to the RERA so that all other provisions are of course, not available. You need not go to city civil court, but of course, consumer court is still available. Now, as far as FSI in suburb area is concerned, if the road width, it all depends on the road width. If it is more than 9 meter, up to 12 meter, of course, it is 2.7 FSI. There is 1 FSI, 1.5 premium FSI, 0.5 TDR, this way 2, and then 35% fungible FSI. If it is 12 meter and above up to 18 meter, of course, it is again 2.2 FSI. Then 0.5 you have got a premium FSI, 0.5 you have a TDR. Then it becomes 2.2 plus you have fungible FSI. That way it becomes 2.7. Then of course 2.4 also is there plus fungible FSI depending on the road width, and if it's a cluster development there is 4 FSI plus fungible FSI. So these are the various norms as far as FSI is concerned. But of course, as I said, you need to go through the process. You have asked for the name of the book. It is a compendium of self-redevelopment authored by IAS officer, retired IAS officer along with me and other 50 co-authors. That is compendium of self-redevelopment. Next question is, in the redevelopment, if you want to buy the extra area from the developer, then how much percentage less they can compare to the sale price? Amit ji, can you answer this? In the redevelopment, if you want to buy extra area over and above the free area, what should be the rate or percentage discount that we can expect from the developer?
See, normally the formula they use is we'll give 10% discount. But please don't go into this trap of 10% discount. This, how do you arrive at the market rate? See what happens, developers normally tell, ki, sir, I want 10%. So developer will tell, okay, I'll give 10% on the market rate. But now how do you arrive at the market rate? So there are two formulas how we can get the market rate. First, understand the ready reckoner rate of that area. If suppose in the ready reckoner area of, say, example, let's take Andheri. If the ready reckoner area in Andheri is, say, about 18,000 or 20,000, ready reckoner area, ready reckoner rate I am talking, okay? The market rate could be about 25 to 30,000, which normally is about 20 or 25% extra. But how we arrive at it, we take the quotation from 3 brokers of that area, okay? We understand what are the actual rates going on. 3 independent brokers who don't know each other, we take their quotation, we arrive at the average rate of those 3 quotations. That becomes a market rate. And then you calculate and reduce the ready reckoner rate. That difference is there, on that you negotiate. And then you take the discount based on that, which could be about 10 or 15%. So arriving the market value is more important than actually taking the discount. You may just give more, he may give more discount, but he is giving you higher market rate.
Correct. So it is a very, very good formula you are given. It is very important if you can be included in the DA itself. Many of the societies, they include the price for the extra area in the DA itself, and they also give how much is the additional area they can purchase at the discounted price. So instead of keeping it open, it is better in the DA itself. You mentioned that additional area to the existing member up to additional 10%, they will offer at 10,000, 20,000, 12,000, whatever the rate prevailing, that can be mentioned. That becomes much easier. Lakshmanji has a question, Advocate Mehtaji. PAAA has been signed by the nominee and his brother has challenged the same. Even the society has challenged. So what is to be done?
If PAAA, how can the society challenge? Because the PAAA cannot be executed. The society is not a party to it. The society had to be party to that. Correct. So it is very difficult to understand how the society is not party to a PAAA. However, let's
Lakshman, are you there? Lakshmanji? Lakshmanji, can you explain this? Okay. No problem.
Hello.
Yeah, Lakshman.
PAAA has signed by the elder brother.
Okay.
The younger brother has sued the society. He has taken the society to the court.
Okay.
The brother and the younger brother has taken the society to the court.
Okay. Understood. Yeah, go ahead, Amit.
Yeah. So I presume that the society is a party to the PAAA.
Correct.
PAAA cannot be
independently party, and therefore younger brother has challenged it before the court against the society.
The society and the elder brother.
The
yeah. So that is okay. Let the courts decide whether who is the right nominee and who is not.
Correct.
Yeah.
Sir, PAAA can be executed even with the nominee, because at the end of the day, nominee is a trustee. Nominee does not get the ownership. Just because the PAAA has been signed through the nominee does not mean that he becomes the owner. Many of the people are under the misconception. If you don't execute a PAAA, commencement certificate does not come. If there is a dispute between the nominee and his brothers and other legal heirs, how can society keep quiet? And therefore, we also have received one High Court judgment directing the society to execute the PAAA through the nominee, with the nominee, and then leave the nominee to bring other legal heirs on the record later on. This is just a accommodation that PAAA will have a clause that PAAA has been executed with the nominee, and it is the responsibility of the nominee to bring a legal heir and execute the subsequent deed with the legal heirs. So this can be done. Otherwise, if you don't do the PAAA, you do not get the commencement certificate. So therefore, this is very important. Sir, Amit Mehta ji, you have a question by Milan Mehta. If a developer does not give the bank guarantee and shows funding from own company, but not give solvency certificate also towards his capacity, does it not clearly point out a big risk to the society?
Yeah, the risk could be there, but you need to do a proper due diligence. It may not be necessary that because he doesn't give bank guarantee, he is not solvent enough. Because bank guarantee also costs more today. Earlier, the 20% amount was to be deposited, then it became 50%. Now it is 100% deposit to the bank if you want to avail a bank guarantee. Please note that getting security doesn't mean that you are getting the best of the security. This security also means that they will cut corners at somewhere else because it's a cost. It's a cost to the developer. So from where will he recover this cost? He will recover the cost from the society. So merely getting a bank guarantee doesn't mean that you are safeguarded in 100% way. It only means that you have some safety by which if there is a dispute between you and the developer, then there are certain things by which you can encash it for some point of time till the time your members can survive on the rent, which can be encashed to this bank guarantee.
Okay. Now we will take another 2 or 3 questions. Dharmesh ji, can we conclude after 5-10 minutes?
Sure.
Yeah. So we'll take one question. Builders are now refusing to give bank guarantee. Okay, Amit Mehta ji. Builders are now refusing to give bank guarantee. They are giving lien on a certain flats in the project. Which one is better for members of the society as security? Bank guarantee or a lien of the flats, which is better?
Obviously, bank guarantee is better. The lien of a flat is somewhere which is in the air, and you don't take something in the air as a security. However, I can give one tip to all the members who are participating today. What we as lawyers do, and this is a very unique idea which you have started taking. If the builder is not ready to give a bank guarantee, and if the society agrees to take the lien of certain flats, and these flats are those flats which are in the air, then we also take an equivalent amount of a post-dated check, which is not dated, which is undated, of equivalent amount. And that can be kept as the escrow guarantee that in case the developer fails to proceed ahead or fails to complete the project, then this check can be deposited with a certain escrow letter. In that, a specific line will be written that this check will be deposited by the society to the bank with no further reference to the developer in case the developer defaults in the terms and conditions of the development agreement. So if you are taking the lien of a flat, this additional coverage you can take, and this the developers will happily give. The reason is that their money is not getting stuck. It's still a check only. There is no certain amount which is getting stuck. So you get an additional double layer of benefit as far as security is concerned.
Okay, if the lien flats are already constructed and there is a OC, maybe of the already completed another redevelopment project, is it advisable to take such flats on a lien?
Yes, that would be advisable. Then better take a lien of a flat which is not in your building, in your rather proposed building, and from another building.
Okay. Would you appreciate reply to questions about 33.9? So 33.9, there is a question that what are the various benefits under 33.9? That is a cluster development. Please throw some light on the responsibility of the developer in the case of 33.9 cluster development vis-a-vis MADA flats, etc. in the western suburb. So shall I answer this, Amit?
Yeah, in 33.9, I would not be able to in a capacity to give a lot of light on that.
Okay. See, there is no difference between 33.9 and 33.7 or any type of redevelopment. Let me tell you, whether it is through the premium FSI, other thing, all the responsibilities of the developer remains the same. And it becomes, once the developer takes a cluster development, then certain area need to be given to the MADA as a part of the DCR provisions, and that has to be given by the developer. It has nothing to do with the society. So therefore, you don't have to worry on that aspect. And the second question you are saying, Mumbai city hardly any projects are registered with MahaRERA. No, let me tell you, because the redevelopment in South Mumbai is not happening the way it is happening in suburb, and therefore you don't find many, this one RERA registered project in South Mumbai. But if they want to sell the flats, naturally it has to be registered with MahaRERA, otherwise they cannot sell. So therefore, I'm not very sure that without RERA registration, they will not be able to sell the flat. Now, for redevelopment, just one question. Okay. Now, for redevelopment of community, is the property card mandatory before signing the DA? As we have already said, that unless until you have a property card in your name, it is not advisable to sign the development agreement and go for redevelopment. Otherwise, it will attract a lot of litigations. Section 41, exemption from compulsory. Can we get this facility on the redevelopment? The answer is no. Section 41 of the Maharashtra Cooperative Society Act says, in case you want to transfer the shares, then agreement to transfer the share need not be registered. But that does not mean that redevelopment agreement need not be registered or PAAA need not be registered. They are all wrong. So with this, I think Amit ji has given a very good suggestion that in case the developers are not able to give the bank guarantee, you can take a check including the lien of certain flats, which will facilitate. And Amit ji, you can conclude some of your suggestions to make the redevelopment a successful. How the redevelopment can be made successful in the various controversies. One, regarding the dissenting member, how to handle the dissenting member. Secondly, if the developers are not starting the projects the way they have promised, how we will be able to encounter. And the third and most important is, when the project becomes stalled, then how we will be able to use the legal system to get the project revived. These are the three simple questions, and you can conclude.
Yeah. So, of course, as far as dissenting member is concerned.
Hello. Mr. Amitji, I am Uday Kalbak.
Yeah, hi.
I have one. Hello. Very good morning to you, Amit.
Hi.
I have one question. Just now we were discussing under 33(9). In that there is one clause that if there is an open plot or some public property or some public undertaking properties, and if those properties are contiguous to the plot under consideration for redevelopment, then a developer can purchase that plot by paying the proper consideration to the private property or MADA or whoever is the owner of that MADA. In this case, whether such at what rate is, suppose that MADA is the owner of that plot, then what is the rate MADA will purchase, will sell that flat? That is number one. Second thing, in Bombay, under MADA, whether such things has happened, whether MADA has given or sold that property to the developer or the society.
Yeah, so there are two aspects. One is the plot of a, say, BMC or a collector or a MADA, and second is the property which are there in their name. So there are certain cases where collector land has become a freehold land from collector land. There was a scheme which had come about a year before, where you paid a 15% of the amount of the ready reckoner rate, and the plot becomes of the society or the developer, whoever is purchasing. As far as the property is concerned, the BMC and MADA, there are no such cases where they have sold off their property. but there are schemes where they have given it on a long lease for 19 years or n number of years or 30 years, and then the property is there with the society for a longer time. But the collector land has been sold and they have become from leasehold to freehold by paying certain premium, which normally was 15% recently when the circular had come.
Okay,
Yeah, I will
next
just add, Uday, I understood your question. See, let me tell you, if there is a plot which is owned by the MAHA and you are expecting them to sell it to you, then
No,
what is
sale
the
or
rate they
lease.
will use? Huh?
Sale or lease.
Yeah, sale or lease. Naturally, there are various methodology. You need to approach MAHA VP, and then of course they will calculate as per the ready reckoner value. Certain premium will be levied to you, and you will have to pay the premium. That is a lease premium, and get it. But what will be the exact amount of the premium? All this will be connected with the ready reckoner value. Okay.
No,
Prabhu sir,
my question is whether in such case, hello,
Yeah, go ahead.
hello. My question is whether MAHA in such case can refuse to give it, even if it is mentioned of 39 policy.
Yeah, they can do. We can discuss further. You have number of Mr. Amit Mehta as well as Sandeep Kangutkar. You can discuss with them separately. Okay.
We have put our details on the chat box. You can see our details on the chat box. I put the email ID and the mobile number also in case required.
Yeah.
Prabhu sir, please one question from my side,
Yeah.
please.
Go ahead.
This is
Yeah.
Vandana here. Now, regarding the checks, Amit Mehta sir said ki you can take checks from the developer. Now, if the check bounces, then there will be one more cases going on. Like, here the building will be demolished. And I mean, don't you think this is a very lengthy process? It's better to take bank guarantee always, but our developer is not ready to do so. Any other options, sir, besides the lien and check you mentioned, right? See, because we want our building to be completed in 3 years. But with this litigation going on, then it's very difficult for us to come back to home, right?
See, what is the stage of the project right now?
The thing is, our committee is we have got the deemed conveyance, but we don't have the property card yet in our name. But still, the management committee is going ahead with the builder of their choice. And a few of us had disagreed with it. We are saying until property card is in our name, then only we should go for the DA. So I need your suggestion on this, sir. As Prabhu sir mentioned, yes, there will be litigations, but our managing committee is not ready to agree with this. So what are the this thing? Can you guide me on this, sir? It's very important. Hello.
Yeah. See, Vandana, let me tell you. First and foremost, the check bouncing. If the developer is not ready to give bank guarantee at all, and what is the next option? Naturally, take the check so that if at all he is not giving you the amount or honoring the check, then of course you can file a criminal case and put him behind the bar. So that becomes a deterrent factor. That's it. Now,
No, I just want to know, Ramesh, 1 minute. I want to know from Vandana ji, how many member society is this?
Ours is 50 members, sir. 50 members, corporate.
50, and 3 are opposing.
Yes. Because there was 79A was not at all followed. There was no tender, nothing. The chairman or committee member bought this builder, and they just started working on it. Most of them are defaulters, so they are happy with that redevelopment by any builder. But I feel once the building is demolished, there's no way this builder is going to give us a building on time, because there was no annual report or nothing, feasibility, use financial strength,
okay, he has understood. Yeah, go ahead.
Yeah.
Amit.
So what I'm suggesting, see, it's a very unique case. It should not happen that you are actually right and the majority are wrong. And even then the project has gone ahead. But the fact is that because you are in minority, the courts in India today may not consider minority so seriously unless until you are extraordinary case. Under the apprehension that he is not going to do some certain things, when your apprehension may be right, the courts will not support you because you are apprehending certain things. Unless until it's a tested case and there have been cases against them prior to your project, then obviously then some questions can be raised. But otherwise, I am of the opinion that try to see technically their balance sheet, profit and loss statement. Even though the committee is not cooperating, you can also take out through private route and take out their solvency levels, and that you can always circulate to the entire society that this is a solvency level, and that you are apprehending that you will not be able to complete the project.
So what do you mean by private route? Can you just enlighten on that?
Do one thing, Vandana, you take his number. You can. I also shared my number. We can discuss separately. Now,
Oh, okay.
last question. Lakshmanji has asked.
Thank you.
Stamp duty on descending member and when it triggers. Lakshmanji, let me tell you that if you are a descending member and you have not signed the development agreement as a conferring party, then on the descending member, stamp duty will be payable as per the construction cost, and construction cost on the entire area, including a free area as well as the existing area, and on that 6% stamp duty is payable. If you are a conferring party in the development agreement, then stamp duty is going to be only 100 rupees. So therefore, it is advisable that if you are a minority, then better to sign the development agreement so that your DA, everything will happen and it becomes much convenient for you. Now, the last question by Chandrakant: what benefit society has to get when the lands has to become freehold and the redevelopment is final stage? See, if the your collector land becomes a freehold land, naturally, in future when you are going to sell the flats, you don't require the collector's permission. However, if it is not a freehold flat, still you need to give 10% of the land area as a premium to the collector government to get the development agreement signed or redevelopment done. So therefore, it is advisable that you pay 15% of the land cost and become a freehold. By paying extra 5%, your project becomes freehold. So therefore, it is better if you can do the redevelopment. Rajesh Nambiar, with the introduction of RERA post 2000, what is the mechanism of applicability of MOFA for existing members in the legacy project? See, MOFA and RERA both are existing. It is not that MOFA has been repealed. Government is planning to repeal, but right now it is not repealed. So you can take the benefit of MOFA also to initiate action against the various people. So with this, I request Dharmendra Sharma, the president of Rotary Club Bombay West, to give his final wording, and then Anand Gupta ji will give the vote of thanks. Thank you very much.
Thanks, Rameshji. It was a very interesting seminar, and every participant and the speakers have enlightened all of us. So, due to the time constraint, we have to complete the session. So, I would like to invite our past president Anand Gupta for offering a formal vote of thanks.
Good afternoon, friends. Friends, as you know, this has been a joint venture of Rotary Club of Bombay West and MahaSeWA, and we had organized today 55th lecture. Continuously last 4.5 years we are organizing this, and this is happening continuously. The next lecture is going to be on the 5th of February, and which is going to be on the structural audit and repair. Friends, now present task of giving a vote of thanks to all the guests have been given to me. So first, our thanks is to Advocate Amit Mehta, who has been the author of the RERA Act in the country, who has been also one of the author in for the RERA Act. As he rightly pointed out, the RERA has brought the uniformity throughout the country for all the rules and regulations for housing, and it has definitely brought the credibility of all the developers and in the system. He also very nicely explained the importance of 79A and how fair, if everybody follows it, it will bring the transparency and the accountability, and the chances of any litigation will also get reduced. He also nicely explained the importance of appointment of project management consultant, feasibility report. He also pointed out what care we should take while pre-qualifying the developer for tendering. He also pointed out the various importance of the registered development agreement and the consequences in case we do not have the registered development agreement. Amitji, thank you very much for sparing your time and inviting all our delegates for redevelopment.
Anandji, thank you so much for giving such a nice small thanksgiving speech. Thank you, Dharmendra ji, Ramesh Babu ji. We also have dignitaries here. Tarun Mota ji, very, very senior architect. He's
good.
also there in this for quite some time. Thank you, Tarun Motaji, for being part of this program. Kanji Ritaji, who is a very seasoned developer, he's also there. And Samir Hingu, who has been part of the
Good.
PATA also. So all these people also very silently and nicely heard the entire discussions.
Yes. Abhiji, similarly, I also would like to thank in his absentia, Sandeep, architect Sandeep Kangutkar, for sparing his time and explaining the self-redevelopment and the importance of the road width, importance of the cluster development, and various aspects of the FSI, the fungible FSI, etc. Similarly, I also would like to thank our housing guru Ramesh Prabhuji, who has been the instrumental for organizing this lecture series from last 4.5 years. And similarly, I also would like to thank my own president, Dharmendra Sharma, who has been the leader and contributing for community service. And how can I forget all the delegates? And as rightly pointed out, Amitji, various important guests have come. I also would like to thank all the delegates and all the VIPs participated in this lecture series. Thank you.
Thank you. Good day.
Thank you. Thank you.